Your blessings.
Okay, thanks. Yes.
Have you come back to India?
No, I have not come back to India. I'm still in US. I'm conducting, that's why I told them that I will do it on, online.
Okay, okay.
I think now I can see you, but I am unable to see. Okay. Let the candidate. Yes, okay, right. Mr. Bhattacharya, yes, okay. I'm waiting for. Has anyone come from the registrars? I talked to registrar with Professor Patnaik. Okay.
Yeah. Yes.
Now you tell me the procedure. Yes. Yes. Namaskar. Let Mr. Bhattacharya, Pradeep Bhattacharya may introduce. या सर देखना साउंड वॉइस तेज करना Is the voice not? See, can you raise the voice, please? Yes. There's some problem in sound, you see.
Sir, it has not started yet.
Okay, right. That's good.
Yeah.
Okay, let them take their own time.
Yeah. It has not
Right,
started.
good.
Yeah.
और सब क्या चल रहा है?
ठीक
तो
है
अभी
सर.
किसको आना है? उनके रजिस्ट्रार ऑफिस से कोई आना है किसी को?
अभी पीएचडी सुपरवाइजर तो आ गए हैं.
अच्छा,
राजकुमार सर.
Yes, Rajkumar, yes.
Please introduce yourself.
ఇక్కడ పిహెచ్డి వైవా జరుగుతుంది.
Okay. Yes. Now I can see. Yes. Yes. Okay, but I'm unable to see you. I can see the topic and the name of the scholar, research scholar, the supervisor's name. That is shown in the on the screen, but not. I'm unable to see you. Yes, now it's fine. Now I can see you. It can the voice be raised? See, can you see? Hear me?
Yes, sir.
I think there is some problem in the voice. Can you do something? Hmm. Yes. Can the voice be? Yes. Okay. All right. Then some problem in the voice. Hello. His voice is very slow.
No, sir. I mean,
हाँ.
it has not started yet.
ओके नेट्स फाइन. जब स्टार्ट हो जाता बताइए, तब तक हम बैठे हैं. लेट देम से आई एम वेटिंग.
मैडम शुरू करिए.
ये हाँ ठीक है, जब स्टार्ट हो जाए तो बताइएगा. हाँ.
नहीं, भट्टाचार्य साहब की आवाज नहीं आ रही है. आवाज नहीं आ रही है आपकी.
इसकी अभी तो मैंने. कैन यू हियर मी नाउ?
आपकी आ रही है.
हाँ,
जो
हमारी आप लोगों की आवाज नहीं आ रही क्लियर.
हाँ, रिसर्च स्कॉलर की आवाज नहीं आ रही है.
हाँ, बिल्कुल नहीं आ रही है.
This mic, maybe
Yes.
this right to focus on this.
This is working. Am I audible now, sir?
Yes,
Yes,
now it
sir.
is fine. Yes, but
Yeah.
I've yet to see you. See, it is audible now.
I am audible?
Oh,
Yes,
yes, certainly.
Yes.
Sure.
Yes,
Sir,
very
my,
much audible.
my
I
subject
can
is,
hear you like anything. Yes. Now
My-
it's good.
my subject is impact of long pending cases on socio-economic aspects of parties involved, a study of cases in civil courts. First of all, sir, I would like to explain what is long pending cases. Long pending cases are delay in disposal of cases. Now, Lord, the question is that the Limitation Act would come for any suit. The Limitation Act Section 3 is applicable, and Limitation Act 1963 is applicable to suits as per Section 3 suits, appeal and application. And that is maximum for 12 years if the matter is involved property and otherwise. But the question is that if the delay is there, then it is to be equally disposed of by the court. But the Limitation Act is not applicable for the courts. That is the big impediment so far the disposal of the case is concerned. And second point,
Well, sorry to interfere. Sorry to intervene. I cannot see your face. I'm only seeing the screen. Hello? I'm only seeing the screen. I'm not seeing your face. Presenting the same. Hello?
now sir,
Yes, now it's fine. Now I can see you. Yes,
go back.
please. Yes.
My,
So while sharing the screen, the face of the presenter may not be visible, sir. But once the presentation is over, we'll close the PPT and we'll open the view, sir. Is it okay with you?
No issue left.
Right, sir. Right, sir. We'll just share the screen.
Yes.
now I begin. Ab initio. Impact of,
Okay.
my topic is impact of long pending cases on socio-economic aspects of parties involved. A study of cases in civil courts. Long pending cases are, according to me, it is the delay in disposal of cases. So far the Limitation Act is concerned, 1963, sir, that is applicable as per section 3 to suits, appeal and applications. But so far the court is concerned, Limitation Act is not applicable. So how the disposal of the cases would be controlled? For that, there is no any specific provision in the CP code. You read with Limitation Act 1963. My humble submission would be then, the second word is socio-economic aspects of parties. Socio-economic, these words I have collected from the sermon given by our Chief Justice of India, Sri Deepak Mishra, where he said that his lordship said that every case is human face, meaning thereby that therefrom the socio-economic manifestation is reflected. My humble submission before before the august body would be that how this can be manifested more, because my main question is that we always see how the case can be disposed of, and third is that a study of cases in civil courts. My another point is that all the civil cases which I have personally conducted, that is now running delay for more than 30 years, I am trying to understand what is the cause behind it that case is being lengthened, why the case is being stretched. My curiosity approach raised, I got the curiosity inspiration that if the litigants are getting lot of financial crisis, lot of pains, yet they are waiting for the poetic judgment, the justice from the court. This is the thing I'm trying to understand, how to build the balance factor between the two postulates. One is if the judgment is disposal is delayed, then there is the denial of justice. And second, if the hurriedness is there, then the justice should be done. I want that there should be balance factor. There should be balance factor. Thereafter, in connection with my subject matter, I have prepared a questionnaire. That questionnaire, sir, I have mentioned the first questionnaire point is very important that I want to place. Kindly see my page book, number 212. Now,
Yes.
still, sir, first, this is litigant questionnaire. This first, cases in courts are not disposed of as early as possible. I have said even in court judgments for delay. I believe court cases may be fought by moneyed persons. I believe everything ends up in court. I am ready to face number 5, a legal battle for a long time. Whether you feel by legal battles in courts to get social recognition. 7, the legal battle is a burden for my family. Third, 8, I am in a crossroads due to legal battle in court. Sir, if this questionnaire will be examined, your lordship will find that cases in courts are not disposed of as early as possible. That means delay is spontaneous that I have tried to know from them. The result I will give later on. Second question, I have faith even in court judgment for delay. That means even if delay is there, the litigants are awaiting for the judgment. Sir, you will appreciate that the case is instituted under section 26. Then it goes through the trial, then judgment comes under section 33. Now, its journey is from 26 to 33. Meanwhile, the delay is there. Why the delay? And what is the remedy for delay? Sir, if you see the CPC, that is as per section 35B, there is the cost imposition of cost provision there. And as per order 17, rule 1, 3 adjournments are there. This is the restriction. So far the CPC is concerned, this is the restriction. But even that is there, why the cases are being lengthened, why the cases are being delayed, that was my searching point. Now, sir, what is the problem? Problem is that while the court frames the issue as per order 14, rule 1, sub-rule 4, A and B of the CPC, two issues are there, two types of issues are there. One issues of fact, and another issues of law. So far fact is concerned, that is there, by the evidence is there. Issues of law, there is some dichotomical approach by the court. Otherwise, see, if the first judgment comes under order 20, rule 5 of the CPC, then the first appeal is filed under section 96. In the appeal, you would appreciate that the grounds are taken. So far the issues by the trial court, that is framed on the basis of the pleading. Pleading means, as per order 6, rule 1, pleading means plain, pleading means WS. From after reading the pleading of the parties, the court frames issue. And on that issue, but what is the problem? Problem is that when after hearing both the parties, when the findings are given by the court, your honor would find everywhere there is some lapses on the part of the court, not mentioning the entire evidence, configuration of the evidence, which provides the gap there. Now, when the first appeal comes under section 96, this appeal are made on the grounds objection to the judgment.
Go as per the slide and make it.
Okay.
But only point is that many more trial court judgments, sir, you find that they are not mentioning the paragraphs of the evidences that are recorded under order 18, rule 4, sub-rule 1 of the CPC. Now, the new system has been introduced. My say is that if the paragraphs are not mentioned, then difficulty would be how the factum of the cases would be explained before the trial at first appellate court. Now, first appellate court frames points for determination under order 41, rule 31 of the CP code. But normally, sir, you find that the court doesn't frame the points for determination. For that, the argument is delayed. My humble submission before the honorable, if the court frames the points for determination under order 41, rule 31, then the argument will be shortened and to the point. Now, if the first appeal is dismissed, then the second court comes under the second appeal under section 100 of the CP code. There you would appreciate the second appellate court frame the substantial point of substantial questions of law. In the substantial question of law, it is suffered from order 14, rule 14, because legal issues are not well framed. That's why the substantial question of law are also different. Now, if that is there, then the appeal before the Honorable Supreme Court, that is as per section 109.
Slide by सबसे चलिए थोड़ा fast चलिए है ना just go as per the slide sir का timing है
Now, sir, second thing is that if that is there, that we are getting, because just one example I say, one case I am conducting in the High Court, that was instituted in the year 1969. Yesterday, matter was argued by me in the divisional court. Only point is that, sir, for an example, that giving an example so that you honor find the point that where the lapses are there. The point is that the divisional court has directed to substitute the errors of the deceased decree holder. Question is that as per Order 21, Rule 16, the transferee of the decree is coming to the place. But where the question of substitution comes under Order 22, Rule 3 and 4 of the CP Code. So, my say is that if the legal procedure would not be rightly followed, the delay would be caused. An argument is being lengthened. Again, it is being stressed up. Second,
इसको छोड़ दीजिए
again, I am coming to a point.
as per slide चलिए sir
Now, sir, inclusion of one law point is there. Yashpal Jain versus Sushila Devi delivered on 20th October 23. What happened there? There, the main problem is that LR problem is there. Which yesterday I was mentioning, arguing before the Honorable High Court. That decision I relied upon, that LR, how LR can be substituted in the revisional code. Only Order 21, Rule 16 will be applied. So again, court is going back. Now 69, now it is running 25. Lordship kindly decide what the time there is. Still, the law has not put into the right box. My humble submission would be that if the legal procedure would not be followed in right way, then this delay would be continued. So expertise of law from both bar and bench is required. Otherwise, we cannot go ahead. Third is that socio-economic effect of long pending cases in court, cases more than 5 years at court of first instance, is a big social element. Because you would appreciate, sir, your honor would appreciate me that the court expenses are guided by Court Fees Act as well as cost, as well as advocates' fees. If the time would be extended in this way, the socio-economic impact would be very much gravitous before the litigant. One important point is that owing to lack of strategic concept of management, here lies the main thing. Management science must be introduced in the legal parlance, in the administration of justice, because you see, cause list that is prepared, it is most heterogeneous way. Suppose today one order has been passed, next day that is again another order is passed. In this way, the heterogeneous management system in the cause list, which is the parts of the whole proceeding, therefore that strategic concept of management must be introduced. Honorable Supreme Court judges have already given their verdict that see, court management should be well equipped so that the cause list, daily cause list should be in seriatim and the case can be heard. And third point is that according to 2005 World Bank survey data, about 12.5% of firms involved in court cases over the period 2001 up to 2004, and about 22.5% of the firm report or contract enforcement as a constant doing business. Now, Contract Act. What is Contract Act? Contract Act, both the parties have got their liabilities, and normally at the first instance, the status quo is maintained, both parties go according to their liability. But where the problem arises when the terms of the contract are breached, and naturally Section 73 of the Contract Act comes into place, and that is not at all settled by the parties. Now, in all agreement, here it is a global agreement or national agreement, you honor would find there is a provision of arbitration under section 7 of the Arbitration and Conciliation Act 1996. But even the arbitration clause, even the arbitrator is appointed. Again, section 34 comes, and very recently one decision has been filed. Even then also, if the section 34 matter is disposed of, again the matter went up to Supreme Court, and Supreme Court, as per Article 142, applied the no, it can be modified. In this way, the delay is also there. Naturally, I would see there is some judicial reform is required, and that judicial reform is to just maintain the status quo. In what manner? In my according to me, sir, the Limitation Act 1963 must include now what shall be the time frame for the court to pass the verdict, judgment, what will be the time frame for passing disposing of the suit application. This is highly needed. Otherwise, if the Limitation Act 1963 will be one-sided only for suits, that is by litigant, only for appeal, that is by litigant, only for application, interlocutory application by the litigant, then my humble submission before your honor would be that the other side court will get the free hand, and if the court, the restriction would not be brought about, so but the limitation of passing the order is not brought about, the problem could be will go ahead in this way. And the important, but even without obtaining justice, he cannot leave the field despite incurring huge expenses unless relishing fruit of the poetic justice in terms of socio-economic impact, that is court expenses and monetary strength of litigants, which indicates his social state. That's why the Chief Justice of India, Deepak Mishra of Cuttack Law College, clearly held that every case is human face, and seeing that the socio-economical manifestation is there, the suit should be disposed of. Disposal of the cases must be rapid, and his lordship held that there should be well management of science, all equipment should be there, addition of the judges should be there. In this way, the matter can be solved. These all matters super matter. No, sir, review of literature. If your honor would see the review of literature, I have made studies of more than 59 cases there, more than 59 cases, 65 cases there, and I have tried to resemble that findings, that verdict to my subject. Whether that all subject pertaining to delay, and if the delay is there, for what cause behind it the cases are being delayed. And in that, after they reading all these things, I have decided to approve that, to minimize the delay would not be eliminated, cannot be uprooted, but we can minimize it in this way by bringing better court management in the administration of justice with all equipments. Most importantly, I have mentioned there, court management suffers from expertise as to how arrange the cases for hearing. This is the impetus of my deliberation. I much more stress upon this particular line.
I think you command the analysis part. What's your analysis and what's your findings and all the.
Go with the hypothesis. Essentially, hypothesis.
Hypothesis so far is that there is no significant difference of opinion among the litigants and advocates on the perception and attitude towards court proceeding and legal system based on their demographic profile. First, there is a significant difference of opinion among the litigants and advocates on the perception and attitude towards court proceeding and legal system based on their demographic profile. Such hypothesis, there is no significant difference of opinion among the litigants on the perception and attitude towards court proceedings and legal system based on gender. There is significant difference of opinion among the litigants on the perception and attitude towards court proceeding and the legal system based on gender. Two, there is no significant difference of opinion among the litigants on the perception and attitude towards court proceeding and the legal system based on age. Two, there is a significant difference of opinion among the litigants on the perception and attitude towards the court proceeding and legal system based on age. Three, there is no significant difference of opinion among the litigants on the perception and attitude towards court proceeding and the legal system based on annual income. There is a significant difference of opinion among the litigants on the perception and attitude towards court proceeding and legal system based on annual income. That's a research methodology. Types of research I mentioned there. I've given the research methodology also that can be seen, and research design I have made that relates to mixed research, qualitative, quantitative, and about population. Meanwhile, point of oscillation, I have given the chart, I have given the data coding, entry, data coding, entry, cleaning, Excel, all these things I have done. Overall, the situation I have placed, but still I say, if the management science would not be introduced there in terms of this all calculation, my say is that, my opinion is that delay would be the natural phenomenon if the case is brought before the courts of any court. That is, either it is a trial court or it is an appellate court or it is a Supreme Court, anywhere else. You should go. These all figures indicate there is everything is there, but independent. Even I have done the independent details for the findings. There is no.
I think those things okay. So you come on your what peculiar suggestions.
My suggestion is that, in short, my say is that my suggestion would be the management science expertise court manager should be there. Number one, they would arrange the cause list according to the status of the case, according to the hearing status, status of the case. And second, there should be also add of judges in the courts in proportion to litigants, and court where the infrastructure must be well advanced. And third, most important is that, sir, my question, I have also put so many questions to the judicial officers. First is that the rule directly proportional to the law. Do laws make these all questions I have put? And they have also ultimately come to the conclusion, yes, Mr. Bhattacharyya, it is required, the expertise should be there, and unless that is not, that your honor would appreciate, there are two ways. One is judicial adjudication, one is ministerial adjudication. Ministerial adjudication is by the court manager. If he would not be expert, the problem would be again recurrent, and the problem would be never eliminated. And that's why the cause list, which is displayed in the board for court cases, that should be homogeneous in terms of the expertise applied by the court manager, so that what sort of hearings could be in seriatim, that should be well categorized.
Okay, I think by your presentation is very good. And one more thing, your studies focus on code management. How code management is to be impact and involve the improvement of speedy justice.
Yes.
So in India, there is the speedy for the sake of this code management. The Supreme Court started one of these plan to each and every court is try to be appoint a code managers from the 2010. So you have any case study? What is the impact of the court managers in terms of the?
Yes, today the question I have mentioned that still they are not well equipped so far the law is concerned. Right? When they arrange the court cases, they must know what is the next follow-up of the procedural situation. They are not so expert. Only management not. Legal expertness should be there. Legal expertness in terms of the management. Okay. Or management side in terms of the legal expertise. That should be there. They should be also equally legal, the knowledge they should also have.
Okay, good. So you mentioned in your presentation that the judicial adjudication and ministerial adjudication.
Ministerial method, that is by the bench clerk, by the court clerk, that is all comes under the purview of the court management.
Okay.
There should be one court management who should be also legal expertise also. At least he should be legal graduate, law graduate. Otherwise, how he can understand? How he can understand the status of the cases, sir?
Okay. Your suggestion is very good. So how can government of India, how can a judiciary, your suggestion is going to implement? What is the modus operandi to implement this?
Very simple point, sir. Let there be infrastructure increased.
Okay.
And that should be there. And in our High Court also, they are trying to enlarge that.
Actually, right now, each and every states, there is the judicial training academy, and at national level, there is the national.
Sir, I am also happy that judicial training, but for whom?
Yeah.
But for whom? For the court manager should be there. What is the goodies of giving them? Because they would learn from the advocates. All the judicial officers would be imparted by the, or they will be helped, assisted by the advocate, because we have the court officer. But what about the court managers and this ministerial staff? My suggestion would be, sir, that court ministerial staff should be also well equipped with the laws, so that they can just make the roll call or say the daily cause list well in this manner.
At present, is there any policy regarding dealing with this huge number of dependency of the cases? Government of India is.
Sir, your question, I would say, sir, I have already attended the seminar. They are simply telling what will be the operation of the Consumer Protection Act. They are much more stressing about Consumer Protection Act. They are much more telling about stressing, emphasizing on Section 89, that is the settlement outside the code. But sir, it is a half-hearted judgment. On Section 89, no litigant is satisfied unless they are being heard and finally the court passes the verdict. My say is that while the judicial training would be there, academy would be there, these all court managers should be also there. They should equally learn what is the method, so that the case can be, because they are not going into the Section 33, but they are much more interested. So for Section 22, Section 26 is concerned, they can search whether the court fees are rightly placed or not, whether the suit is barred or not under Section 3. These are the outline knowledge which can be easily applied by the court manager. So I think that in that sense also they should be well imparted in the judicial training.
So from my side, it's
Any question, sir?
sir.
Yes. Well, it was indeed a pleasure to read your thesis and the observations. But basic issue is whether the prolonged pendency of civil cases violate the litigants' fundamental rights to timely adjudicate under Article 21 of the Constitution.
Yes.
This is the basic issue which we have to submit. And for your information, I would like to say that starting from Malimat Committee, I think you have not mentioned about that one. That was the starting point. And from that, the recent Law Commission's report is 278.
270.
Which I think which came after you submitted your thesis. But I think this will certainly highlight the issues. But the basic issue which I have framed here is the issue of violation of fundamental right. Because that if we are able to meet that one, I think we'll be able to solve many issues. The second issue where I would like to help you is about the decision which was made in Salim Advocate versus Bar Association of India, where the Supreme Court had an occasion to suggest the anomaly. They have pointed out the anomaly in Rule 14.4 of the Orders 7 of the CPC. And there they've suggested the amendment. Of course, till date, no amendment has taken place. But I think these are the issues which need to be addressed.
If the Law Commission suggestion will not be enacted, but then what is the good use of that?
No, I agree. It has not been done, but I'm just telling you that, whatever you have pointed out about the Law Commission, I'm just like to point out that recently there is another Law Commission report of 278, which is extremely relevant. This is just to be added when you try to publish your thesis. And the second one is, I'm just helping you, that in the season of 2005, which I said that they have suggested the anomaly, but unfortunately till date, no amendment has taken place. So I think these are the issues which need to be addressed. Then the question is the time limit prescribed under the first issue is about the fundamental rights. The second issue is, has the time limit which has been prescribed is that under the Code of Civil Procedure to be interpreted as a directory or mandatory? That's another issue which need to be addressed. Now, if it is directory, then judicial discretion is there. Okay, the real problem arises in the judicial discretion. Judicial discretion, say, is the real issue where the adjournment is granted. So that discretion, how far the higher courts are able to evolve some principles to regulate the, because number of directives have been given by the higher judiciary in that regard. But I think still the real issue is about the exercise of judicial discretion for granting adjournment. Because adjournment, we have to, when you analyze what are the grounds for the adjournment, if you look, sometimes we have to find a way to meet that issue, because unless until you look to the issues, the broader issues, perhaps we may not be able to solve the problems. So I think that is the basic issue of, because adjournment is granted for certain, and we have to lay down a principle for that one. There should be an exception to the rule, and unless until you do that, we will not be able to solve it. Are you listening? So I think I have carefully read your observations at an occasion, and then I tried to find out that how to, because you have done a lot of work, and I'm highly impressed by that. But these are the issues which need to be addressed. And see, when you try to publish it, you must try to look into those issues, because unless you are able to formulate the basic issue, because my starting point, had I been to your place, would be whether it is violative of fundamental rights of Article 21 of the Constitution. Then the question is about the discretion. Is the time limit which is prescribed, if it is directory, even those directory also should be read as may, or may shall be read as shall. I think that also need to be addressed. The third is about the judicial discretion. Despite the Law Commission report, despite the Supreme Court decisions, till date, the judicial discretion is exercised not in a proper manner. And I think that is the basic issue which need to be addressed. I'm just raising, I'm trying to help you. And then when the Supreme Court of India has analyzed and identified the systematic cause of delay, then the problem is excessive documentation, non-appearance of witnesses, indiscriminate grant of adjournment, delay in service of summons, inadequate implementation of the provisions of the CPC and CRPC. I think these are the issues which is to be tackled. Because I had an occasion to be a part of some of the reports in the Law Commission of India, particularly when the Code of Criminal Procedure, the amendments which I have suggested. So I think I looked into it deeply, and I'm mostly concerned about it. I'm happy that you have tried to meet several issues, and I must congratulate you for the same. But I
Yes,
think
sir.
these are the basic issues which also need to be addressed. Because now I'm not in India, so I'm not say that's why I'm trying to help you that when you try to publish your work, I think you please look into it.
And
So I
will
think
add-
these are the only some of the observations which I would like to tell you, and I want to take your reaction, because these are the issues according to me which need to be addressed, and I think in order to rectify these anomalies through legislative amendments and for the benefits of the stakeholders and the justice delivery system.
Obliged, sir.
So
Very nice.
thanks.
Right.
Yeah, I think. Thank you so much. I think I am not. I'm here to help you and to guide you. Rather, I'm not your. But I think as an external examiner, I'm trying to tell you that how these issues are to be tackled, and what are the basic issues which need to be addressed. So I think, so far as I am concerned, these are I've already, as he pointed out, and I think anybody from Registrar's Office?
Yes, we are.
Yes. Okay, you have come, yes. I think now what needs to be done for the Viva voce examination, can I, pardon? You will send it to me? I am unable to hear you. I think there is some problem in your voice. See, please look into, yes. I'm unable to hear you. There is some, it is, yes.
Sir, this is Dr. Pritha Chaturvedi here from ICFA University, Jharkhand. Sir, some
Okay.
documents he sent to your kind office, and those papers are required to be submitted back to us, sir. It would be on the
Yes.
evaluation and the feedback.
Orally.
Okay, that's true. That I will do. That's why I say that for Viva voce conduct, because we get it from a performer from the university, which I have to sign. Okay. But I think
Sir, will your
should I?
kind permission
What is the rule? What is the rule? So, what declaration of result is concerned, Viva voce, is it to be declared right now?
Sir, if it
Pardon?
is satisfactory for you, we can declare him informally and
Yes,
let
it is highly satisfactory. I highly recommend. See, so for congratulations, yes. Okay. So please send it to me on my email, and then I will sign it and send it to you. Okay. So I congratulate him for the, I think, his great efforts, and I'm satisfied. I've asked searching questions, and I'm satisfied with that. Thank you.
Both the external
Congratulations, Mr. Bhattacharya.
declared, like on behalf of ICFA University Jharkhand, sir, with the permission of both the external, I would request you to confirm the same. Thank you.
So, thank you so much, sir. And I think presentation was very good. So, on behalf of this presentation and on this good presentation and all these reports is very much positive. So, we can congratulate the candidates. He is now a doctor.
Yes, certainly. That's why I've already.
Sorry.
So far I am concerned, I'm trying to, yes, please congratulate him on my behalf. I'm myself congratulating him.
Okay.
Yes.
So, one request to you, sir. I have some another appointment, so we can, with your permission, kind permission, we can leave, sir.
Oh, certainly. I also, because it is 10 p.m. here
Sure.
in the US.
Great meeting
Okay,
sir,
thank
with
you.
sir.
Thanks a lot. Okay,
Thank you,
bye.
sir.
Subhashini,
Okay, bye.
Subhashini ma'am, any questions from you or comments from you, madam? We have Subhashini ma'am from our HO, IFHC. So, we will...
Sir,
Yes.
good morning,
Okay.
everyone. First, I want to congratulate the PhD scholar who did good efforts on this. From my side, I'm not having any questions, sir, except congratulating him, sir.
Ma'am, we'll send the
Okay.
thesis Ma'am. We'll send the thesis to you once it has been declared. So we'll send the soft copy to you, ma'am, for your.
Thank you, sir.
Okay,
Thank you,
you.
sir.
Oh, thanks.
Thank you so much, sir. Thank you, sir.
Thank you,
Okay,
sir.
bye.
Congratulations to you all.